Hello and welcome. I am Dr. Simranjeet Kaur, and in this lecture, I'll be taking you through a fascinating idea in the jurisprudence, the Volksgeist theory. We'll look at how law is seen not as something handed down by lawmakers, but by something that rises from the very spirit of the people. This concept, developed by the Savigny, help us understand why law in a different societies looks and feels so different. So in this lecture, we will try to understand the meaning and the origin of the Volksgeist theory, to explore Savigny's belief in law as the reflection of a nation's spirit and the culture, to examine how customs and the traditions form the basis of the law, to analyze the strengths and the criticism of the theory. By the end of this session, you will be able to define Volksgeist and understand its role in the development of the legal system. Explain Savigny's key arguments about the law, cultural, and the national identity. Discuss the limitations of this theory in pluralistic or modern societies. Reflect on its relevance in understanding the legal diversity today. Let's begin with the topic and dive into the spirit of the people, Volksgeist. The Volksgeist theory, also known as the theory of the spirit of the people, is a concept in the jurisprudence that delves deep into the relationship between the collective consciousness of the society and the development of its legal system. Volksgeist is the concept of the law propounded by the Savigny. The term Volksgeist is made by two words. Volks mean people and the Gest means their common will. It means, Volksgeist means that law is the common will of the people, spirit of the people. In a simple sense, Volksgeist is a journal and common perception of the people or the spirit of the people. The main idea of the Savigny behind this theory was that law is an expression of the will of the people, and it does not come from the deliberate legislation, and it develops as a consciousness of the nation's arise. The core of the Volksgeist was that a legal system of a nation is mainly influenced by the historical culture and the tradition of the people, and its growth was located in their acceptance, developed by the Friedrich Karl von Savigny, a prominent German jurist of the 19th century. This theory has left a lasting impact on the field of the legal philosophy. In this article, we will explore Volksgeist theory in detail, examining its origin, key principles, implications, criticisms, and relevance in the modern jurisprudence. Now, let's discuss the origin of the Volksgeist theory. Friedrich Karl von Savigny, born in the Frankfurt, Germany in 1779, was a distinguished legal scholar who significantly contributed to the field of the jurisprudence. During his lifetime, Savigny's education and extensive knowledge of the Roman law influenced his approach to understanding the development of the legal system. He believed that law was not simply a product of reason or deliberate legislation, but was deeply rooted in the historical culture and the tradition of the people. Savigny's fascination with the interplay between the law and the nation's unique character led to the formulation of the Volksgeist theory. The term Volksgeist combined two German words. Volks mean people and Geist means spirit of the people. In the essence, Volksgeist represents the collective will or the spirit of the nation. Savigny posted that the law is the reflection of this collective will and it evolves naturally as the consciousness of the nation unfolds over the time. What is Volksgeist theory? The term Volksgeist combine Volks, people, and just spirit, signify the common will of the people. According to this theory, Law is not a product of the deliberate legislation, but emerges naturally as a society's consciousness evolves over the time. It deeply rooted in the nation's historical cultures, traditions, and collective experience. Savigny's theory emphasized the importance of the historical understanding and opposed the codification of the law, highlighting the role of legal scholars in shaping the legal principles. It continues to influence modern jurisprudence by emphasizing the cultural and historical concept of the legal system. Key principles of the Volksgeist theory. To gain a deeper understanding of the Volksgeist theory, let's explore its fundamental principles. The first one is law as a product of the society. According to Savigny, law is not an abstract concept but rather a product of the people's life within a specific society. It embodies the entire history and the culture of a nation and reflects the inner convictions deeply rooted in the common experience of its members. In this view, the law is intimately tied to the society that creates it. Law develops like language. Savigny drew an analogy between the development of the law and the evolution of the language. Just as language naturally evolves within a society to facilitate the communication, law evolves in conjunctions with the nation's cultural and social development. This development is not a separate entity but an intrinsic part of the nation's identity. Continuous and organic process. Law, according to the Savigny, is the continuous and unbroken process that grows organically within the society. Customary practices and uses initially gains consensus within the society and are willingly adhered to by its members. Over the time, these practices become entrenched and accepted, ultimately forming the basis of the legal norms. Oppositions to the codification severely vehemently opposed the codification of the law, arguing that the legal development should be rooted in the historical knowledge rather than arbitrary legislative acts. He believed that true legal principles should emerge naturally from the historical and cultural context of the nation. Natural and jurist driven development. The theory acknowledges that law initially develops naturally, responding to the internal needs and the values of the society. However, as a society reaches a certain level of civilization, various national activities contribute to further legal development. Legal scholars and the jurists play a vital role in shaping and refining the legal principles. Implications of the Volksgeist theory. The Volksgeist theory has several significant implications within the field of the jurisprudence. Emphasize on the historical understanding, one of the central tenets of the theory is the importance of the historical knowledge in the comprehending the development of the law. To study the law accurately, one must have a thorough understanding of a society's history, culture, and the tradition. Recognition of the organic nature of the law. The theory recognizes that the law is not static entity, but rather than an organic and evolving construct that mirrors the society from which it emerges. This perspective encourages a nuanced appreciation of the legal system as a product of their cultural and historical context. Opposition to the legal positivism. Savigny's opposition to the codification and his emphasis on the organic development of law stand in contrast to the legal positivism, which posits that law is created by the human authority and can be changed or codified at a will. The Volksgeist theory challenges this positivist view by asserting that law arises naturally from the society's collective consciousness. The role of the legal scholars. The theory underscores the role of the legal scholars and the jurists in the development and refinement of the legal principles. They serve as the guardians of the legal traditions and contribute to the evolution of a law as society progresses. Criticism of the Volksgeist theory. While the Volksgeist theory has made significant contribution to the jurisprudence, it is not without its criticism. Critics argue that not only aspects of the societies, cultures, and the traditions should be considered the law. Some practices, such as slavery, may have originated for the reasons unrelated to the common will of the people. Here are the main criticisms of the Volksgeist theory, which is a central concept of the historical school of jurisprudence developed by the Friedrich Karl von Savigny. Vagueness and ambiguity. The term Volksgeist, meaning the spirit of the people, is abstract and difficult to define clearly. The theory lacks clarity regarding who precisely constitute the people and whose will determines the law. Additionally, there is ambiguity about whether the law shapes the Volksgeist or vice versa. It's hard to measure or objectively identify what constitutes the spirit of the people, especially in diverse or multicultural society. Critics ask, who decide what the spirit is? Whose culture or tradition dominates resistance to the legal reform? By emphasizing the traditions and the custom, the theory tends to oppose progressive legal change. It can be used to justify outdated practices simply because they are part of the cultural history, even if they are unjust. Discrimination, patriarchal norms, caste system. Reformers argue that legal system must sometimes break with the tradition to uphold the human rights and equality. Nationalism and exclusion. The Volksgeist theory has been criticized for promoting the legal nationalism, which can foster the legal isolationism and even the cultural superiority. It may ignore or marginalize the minority voices within a nation whose customs differ from the dominant group. In pluralistic society, defining a single national spirit is both problematic and unfair. While Savigny argued that Volksgeist is the exclusive source of law in the society, critics believe that legislation also play a significant role in shaping the modern legal system. Incompatibility with the globalization. In today's interconnected world, many legal systems are influenced by the international norms, human rights, and the transnational legal principle. The Volksgeist approach can limit the legal harmonization and make it difficult to adopt the international standards. Critics note inconsistencies in the Savigny's theory, particularly his recommendations to adopt the Roman law for the modern conditions, despite the emphasizing the importance of the national character in the law. Overemphasis on the past, the theory often looks backward instead of the forward. It may give undue weight to the historical custom, even when they are no longer relevant to the modern society. Critics argue that law must be dynamic and adapt to the current social, technological, and the moral realities. Lack of the rational basis. By focusing on the tradition and organic development, the Volksgeist theory undervalues reasons, logic, and legislative planning. Critics from the analytical schools argue that law must be a system of the rational, codified rules, not just a reflection of evolving customs, ignoring other factors. Savigny's theory neglect other factors that influence the development of law, such as the role of judges and the jurists in creating the legal precedents and the impact of the social, economical, and the political forces. Relevance in the modern jurisprudence. The Volksgeist theory continues to hold the relevance in the modern jurisprudence. Its emphasis on the historical understanding, recognition of the organic nature of the law, and the role of the legal scholars in the legal development are the concept that resonate with the contemporary legal scholars and the practitioners. In an era of globalization and the multiculturalism, the theory reminds us of the importance of understanding the cultural and the historical context within which legal systems operate. It encourages legal scholars to consider the societal and the historical factors that shape legal norms and practices, thereby fostering a more comprehensive and nuanced approach to the jurisprudence. Furthermore, the theory of the opposition to the codification, its emphasis on the gradual evolution of the law, serve as a counterpoint to the positivist point of law as a product of the human legislation. It challenges us to appreciate the complexity and the subtleties of the legal system, recognizing that they are deeply intertwined with the cultures and the histories of the society they governs. Volksgeist theory and its applicability in India. The Volksgeist theory, developed by the Friedrich Karl von Savigny, a prominent German jurist of the 19th century, is the cornerstone of the historical school of jurisprudence. As many times it has mentioned, the term Volksgeist literally translates as the spirit of the people, represents the collective consciousness, traditions, customs, cultural identity of the nation. According to this theory, law is not made arbitrary by the sovereign or by the legislature, but emerges organically from the customs and practices of the people. In India, a land with an ancient civilization, deep rooted custom, and pluralistic legal tradition, the question of whether Volksgeist holds relevance is both interesting and complex. This lecture explores the applicability of the Volksgeist theory in Indian legal context, examining its influence, challenge, and the relevance in the modern constitutional democracy. India's pluralistic and the custom-based tradition. India, with its multicultural, multilingual, and the multi-religious society, provides fertile ground for the Volksgeist theory. Long before the advent of the colonial legal system, Indian society functioned under the customary laws, religious laws, Hindu laws, Islamic laws, and the village based dispute resolution mechanism like panchayats. Even today, personal laws in India, especially concerning marriage, divorce, inheritance, and maintenance, reflects the cultural and religious practices of the different communities. The coexistence of the Hindu, Muslim, Christian, and the Parsi personal law is a clear manifestation of the Volksgeist operating within the Indian legal system framework. For instance, Hindu law largely derived from the ancient text and the custom, still influences the modern statutes like Hindu Marriage Act and the Hindu Succession Act. Muslim law, Sharia, applies to the Muslims in the matter of the personal law based on the Quranic injunctions and the centuries old traditions. These examples underscores that law in India is deeply rooted in the historical and the spiritual fabric of the different communities, an idea consistent with the Volksgeist theory. Recognition of the custom in Indian law. Indian courts have explicitly recognized the role of custom as a source of law, especially under Section 13 of the Hindu Marriage Act, which allows for the divorce based on the custom that have legal recognition. Similarly, customary practices among the tribal group in India are protected under Article 371 and the 5th and 6th schedule of the Constitution, which grant certain communities autonomy to govern themselves through their tradition. In several judgments, the Indian judiciary has acknowledged the binding nature of the custom, provided they are ancient, reasonable, and not against the public policy. This judicial approach echoes Savigny's emphasis on respecting custom as the basis of the law. Challenges to the Volksgeist in India. Despite its relevance, the Volksgeist theory faces several challenges in India. Diversity of the Volksgeist. India is not a culturally and homogeneous country like the Germany of Savigny's time. The idea of a singular India's Volksgeist is a problematic due to the enormous cultural, regional, and religious diversity. What may be considered a valid custom in one community might be aligned or even unacceptable in another. For example, the practice of polygamy is permitted under Muslim personal law but prohibited under Hindu law. The multiplicity makes it difficult to define a unified national spirit or the legal identity. Conflict with the constitutional morality, some customs through Asian may be inconsistent with the Indian constitution, especially with the principle of equality, liberty, and non discrimination. For example, the practice of triple talaq, through rooted in the Muslim tradition, was declared unconstitutional by the Supreme Court in Shaira Bano versus Union of India in year 2017 as it violated the gender equality. Sati, once a custom among the certain Hindu communities, was abolished through the legislation due to its inhuman nature. These instances show that not all the customs can be accepted as a valid law in the modern democratic and constitutional state. Codification and the legislative supremacy. India is a codified legal system with extensive legislation covering almost all the areas of life, from criminal law to commercial law. Codification and the parliamentary lawmaking reflect legal positivism more than the historical jurisprudence. While the customs still play a role in the personal law, they are subordinate to the statutes and the constitutional provision. This limits the scope of the Volksgeist as the primary source of the law. Volksgeist and the Indian judiciary. The Indian judiciary often walks a tightrope between the tradition and the progress. In some cases, courts have upheld the custom as a valid source of law, while in others they have struck them down in the favor of constitutional values. For instance, in Narsu Appa Mali, the Bombay High Court in year 1951, court upheld the validity of the personal laws, holding that they were not subject to the fundamental rights chapter of the Indian Constitution. In contrast, in Joseph Shrine versus Union of India, in year 2018, the Supreme Court struck down the adultery law, a colonial era statute rooted in the traditional journal norms, as unconstitutional. This tension illustrates the dynamic relations between the historical custom and the constitutional principles in India. In concluding remarks, the Volksgeist theory gives us a powerful lens to view law, not as something imposed, but as something that grows from within the society. It emphasizes the legal systems are deeply rooted in collective consciousness, shaped over the time by the shared belief, values, and tradition. The Volksgeist theory, with its focus on the spirit of the people and the organic development of the law, has left an indelible mark on the field of the jurisprudence. While it has faced criticism and challenges, its enduring the relevance lies in its reminder of intricate relationship between law, culture, and history. As per the above mentioned matter, it can be said that Savigny in his theory deliberately focused on his theory of Volksgeist, upon which his research was depending. In this theory, he says that law is derived from the customs, traditions, and the rule of the community, and the spirit of the people are important in the creation of the law, and the role of the sovereign is very less. He thinks that by the deep and the careful study of the customs, the true essence of the law developed, although the theory of the Savigny was not sufficient for making the law and was criticized by many jurists as stated above. But despite all these criticism, Savigny became the founding stone of beginning of the modern day jurisprudence. In the end, we conclude that For better governance of the society, the legislator should develop the law on the basis of the custom and the tradition of the people, the sovereignty of the legislation, and on any grounds, because then only the law can be developed more efficiently and effectively. The Volksgeist theory remained relevant in the Indian context, especially in the personal and the customary law, where the legal system still respects and incorporates the community specific traditions. India's recognition of the plural legal tradition and India's judicial deference to the long standing customs are clear manifestation of this theory in practice. However, the Volksgeist theory cannot operate in isolation in the modern India. It must coexist with the constitutional values, legislative supremacy, and the demand of the progressive society. Custom that contradicts the idea of justice, equality, and the human dignity cannot be allowed to dominate the legal reasoning. Thus, the applicability of the Volksgeist theory in India is nuanced. It is not a dominant theory of jurisprudence, but it plays a supporting role in understanding and interpreting the social legal fabric of the country. Thank you for being the part of this engaging discussion. Law is often seen as black and white, but Volksgeist theory shows us the shades in between. The cultural nuance, the collective spirit, the historical echoes keep the perspective with you as you study the law. It adds meanings beyond the text. I am Dr. Simranjeet Kaur, and I'll see you in our next conversation. Until then, stay curious and stay connected to the world around you.